Presidential reference SC clarifies governor's power over state bill. News. Recently on November 20, 2025, a five-judge constitution bench of Supreme Court responded to the 16th presidential reference made under Article 143 of the Constitution. Background of the case: the President sought the Supreme Court's advisory opinion under Article 143, Clause 1, following constitutional concerns over the delays by Governor and President in granting assent to state bills, particularly in the context of Tamil Nadu related judgment. The controversy arose from an April 8 judgment where the Supreme Court prescribed timelines for granting assent and by invoking Article 142, treating treated 10 pending Tamil Nadu bills as having deemed assent due to prolonged inaction by governor. To resolve the constitutional uncertainty, the President referred 14 specific questions to the Supreme Court regarding the power of court to impose deadlines on constitutional authorities, the constitutional validity of deemed assent, and the scope of powers under Article 200 and 201. Supreme Court's position on 14 key questions. Constitutional option before a governor under Article 200. Article 200 outlines the process of a governor to give assent to a bill passed by the state legislature. The court held that the governor has three options: grant assent, reserve the bill for president's consideration, withhold assent, and return the bill to the legislature with comments for reconsideration. Crucially, the court ruled that there is no option to withhold assent simplister. The governor cannot simply refuse to sign a bill and keep it pending. If they withhold assent, they must return it to the House. Is the governor bound by the aid and advice of the Council of Ministers under Article 200? No. Under Article 163, the governor usually follows the Council of Ministers, but in giving assent to the bills, the Supreme Court held that the governor acts with discretion and is not bound by cabinet advice, since the government would not recommend reconsideration of its own bill. Is the governor's exercise of discretion under Article 200 justiciable? Court cannot examine the wisdom of merits of governor's decision. However, the Supreme Court has held that prolonged and unexplained inaction by a governor is open to judicial review. If a governor keeps a bill pending indefinitely without any decision, the court can direct the governor to act. Is Article 361 an absolute bar to judicial review of the governor's action under Article 200? No. Under Article 361, the governor and president have personal immunity from court proceedings. However, the Supreme Court held that this does not protect the office from judicial review in cases of constitutional inaction, and immunity cannot justify indefinite delays. Can timelines be imposed on governor under Article 200? No. The court overruled its April judgment that set 1 to 3 month timelines. Article 200 uses the phrase as soon as possible, so rigid deadlines are inappropriate. Is the President's discretion under Article 201 justiciable? No. Article 201 deals with bills reserved by the Governor for President. Unlike the Governor, the President's decision to assent or withhold assent cannot be reviewed on merits. Can timelines be imposed on the President under Article 201? No. Judicial timelines cannot bind the President regarding reserved bills. Must the President consult the Supreme Court under Article 143 when a bill is reserved? No. Article 143 allows constitution but does not make it mandatory. Consultation but does not make it mandatory. The President's subjective satisfaction is sufficient. Are decisions of the Governor President justiciable before a bill becomes law? No. Judicial review applies only to enacted laws, not proposed bills. Court cannot adjudicate on a bill before it receives assent. Can Article 142 be used to create deemed assent? No. Article 142 allows the Supreme Court to do complete justice but cannot create a legal fiction to substitute governor's role. Can a bill become law without the governor's assent? No. A bill cannot become law without the governor's assent or the president's if reserved. Is it mandatory for a bench to first decide if a matter requires a be- judge bench under Article 145.3? The court declined to answer, stating it was irrelevant to the reference on legislative assent. Can Article 142 override substantive or procedural provisions of the Constitution? The court clarified that Article 142 cannot override the substantive provisions such as requirement of assent. Does the Constitution bar the Supreme Court from exercising jurisdiction beyond 143 in Union state disputes? The court declined to answer, deeming it irrelevant to the governor's power. Note: for a detailed understanding of the presidential reference under Article 143, refer to the SFG Quarterly April June 2025 edition. Habeas Corpus Petition. News: climate activist Sonam Wangchuk's wife has moved the Supreme Court with a habeas corpus plea seeking his immediate release from preventive detention under the NSA 1980. About habeas corpus petition, the Latin term habeas corpus means to have the body of. It is an order issued by a court directing the person or authority detaining someone to produce the detained individual before the court. If the detention is found illegal, the court orders immediate release. Purpose: the writ ensures swift judicial review of unlawful detention and acts as a bulwark of personal liberty against arbitrary state action. It can be issued against both public authorities and private individuals who unlawfully confine a person. Important judicial standpoints. 1. A.K. Gopalan versus Union of India. The Supreme Court ruled that legality of detention must be judged on the date the court hears the petition, not on the date of initial detention. 2. Habeas corpus after judicial remand. The Supreme Court clarified that the habeas corpus petition can still be entertained even after a judicial remand order only if there is absolute illegality, lack of jurisdiction, or wholesale violation of fundamental rights. Contempt of court. The Supreme Court, with closing contempt proceedings in a recent case, warned that making scandalous allegations against judges after unfavorable judgment erodes public trust and judicial integrity. About contempt of court, meaning contempt of court refers to any act, conduct, or publication that disrespects the authority of the court, disobeys its orders, or obstructs the administration of justice. No constitutional definition. The constitutional does not define contempt of court. The contempt is governed by statutory law. Statutory framework. The Contempt of Court Act 1971, enacted on the recommendation of H.N. Sanyal Committee, provides a uniform legal framework. Types of contempt. Civil contempt, Section 2B. Willful disobedience of a court order or breach of an undertaking given to a court. Criminal contempt, Section 2C. Act or publications that scandalize the court, prejudice judicial proceedings, or obstruct justice. 2006 amendment introduced the requirement that contempt must substantially interfere with the administration of justice. Recognize trust in public interest as a valid defense. Tests applied by the court. Tendency effect test. Whether the act tends to interfere with justice. Real and present danger slash substantial interference test. Whether the act poses a real threat to justice. Fair criticism exception, Section 5. Bona fide and reasoned criticism of judgment is permitted. Initiation of proceedings. Contempt proceedings may be initiated suo motu by Supreme Court or High Court, or on a motion by the Attorney General for Supreme Court or Advocate General for High Courts, or by a third party with prior written consent of Attorney General, Advocate General, as required under the Contempt of Court Act 1971. Punishment. Maximum punishment includes simple imprisonment up to 6 months, fine up to 2000, or both. Punishment may be waived if a sincere apology is accepted. Landmark judgment related to fair criticism versus contemptuous criticism. Ashwini Kumar Ghosh versus Arabinda Bose, 1952. Fair and reasonable criticism of judgment does not amount to contempt. Brahma Prakash Sharma versus State of Uttar Pradesh, 1953. Defamation and contempt are separate legal concepts. PN Dua versus P. Shiv Shankar, 1988. Contempt power should be used sparingly only in cases of real and imminent danger to justice. Anil Ratan Sarkar versus Hirak Ghosh, 2002. Contempt jurisdiction must be exercised with caution and only for clear violations. MV Jayarajan versus HC of Kerala, 2015. Abusive public remarks against court orders constitute criminal contempt. Prashant Bhushan case, 2002. Contempt upheld for tweets highlighted supreme judicial dignity versus free speech debate. Shanmugam at the rate Lakshmi Narayan versus HC of Madras, 2025. Contempt law aims to protect the administration of justice, not individual judges. SC safeguards lawyer client privilege. The Supreme Court reformed lawyer client confidentiality under Section 132 of Bharatiya Shakhya Adhiniyam 2023, barring investigating agencies from summoning advocates of accused person except in limited legal exceptions. Background: the issue arose from an appeal against a Gujarat High Court order upholding police summons to a lawyer in a loan dispute. It gained wider attention after the ED summoned senior advocates, though later withdrawn. The Supreme Court took suo motu cognizance to curb repeated misuse of investigative powers. Key observations of Supreme Court. The Supreme Court held that investigating agencies cannot compel advocates to disclose confidential professional communications made by their clients. Compulsory disclosure of such communication infringes Article 20, Clause 3 of the Constitution, which protects against self incrimination. Forcing an advocate to prejudice a client's interest without client's consent or knowledge was termed unconstitutional by the court. The court reiterated that gathering evidence of guilt is the sole responsibility of the investigating agencies. An advocate cannot be treated as a substitute for investigation. Advocate client privilege based on professional trust is statutorily protected under the Section 132 of Bharatiya Shakhya Adhiniyam BSA 2023. Breach of such confidentiality undermines the integrity of justice delivery system. The court observed that advocates' ability to represent client without fear forms part of their right to practice a profession under Article 19(1)(g) and is linked to Article 21. Scope of lawyer-client privilege under the Bharatiya Sakhya Adhiniyam BSA 2023 covers oral, written, and electronic communications, applies to litigious and non-litigious engagements, continues even without professional engagement, even after the professional engagement ends. Lawyers are exempt from testifying about such communications before any authority or court. Documents held by advocates are not privileged per se unless they contain confidential communications. Exceptions to privilege: disclosure is permitted only if client consent, explicit consent to disclose, illegal purpose, communication was made in furtherance of an illegal act. 3. Crime or fraud. Advocate becomes aware of a crime or fraud during engagement. SC on arrest grounds and language requirement. In Mihir Rajesh Shah versus State of Maharashtra and another, the Supreme Court held that failure to furnish the ground of arrest in a language understood by the arrestee violates fundamental rights, making the arrest illegal. Key constitutional basis: Article 21 protects the life and liberty, personal liberty. Arrest must follow a fair, just, and reasonable procedure. Article 22, Clause 1 mandates that an arrested person must be informed of the grounds of arrest as soon as may be and has the right to consult a legal practitioner. Key highlights of the judgment: right to be informed. Informing the arrestee of the grounds of arrest is a mandatory constitutional safeguard applicable to all offences. Universal applicability: the protection now extends to arrest under all laws, including Bharatiya Nyaya Sanhita, and is not limited to special laws like UAPA or PMLA. Mode of communication: ground of arrest must be in writing and in a language understood by the arrestee. exceptional circumstances. If written grounds cannot be provided immediately, oral communications is permitted. However, written grounds must be furnished within 2 hours and before production before the magistrate for remand. Procedural fairness, merely reading out the grounds or supplying them in an unfamiliar language, does not meet constitutional requirement. Legal consequence, failure to comply renders the arrest illegal. Cryptocurrency as property. News, Maharashtra High Court became the first Indian court to explicitly recognize cryptocurrency as property under Indian law. Key highlights of the ruling. Nature of cryptocurrency. The court held that cryptocurrency is neither currency nor tangible property, but intangible property capable of being enjoyed, possessed, and held in trust. Application of property principles. It reaffirmed the Supreme Court evolved principle of property law apply equally to cryptocurrencies as property is based on enforceable rights. Statutory recognition. The court relied on Section 247A of the Income Tax Act 1961, classifying cryptocurrency as a virtual digital asset and clarified that it is not a speculative transaction. RBI ban clarified. The judgment clarified that the RBI did not ban cryptocurrencies but only restricted banks from facilitating crypto related transactions in 2018. Trust and global perspective, the court recognized that crypto assets are held in trust by exchanges, imposing fiduciary duties, and aligned Indian jurisprudence with global practices in the UK, USA, Singapore, and New Zealand. SE ruling on narco test, the Supreme Court has held that any forced or involuntary narco test is unconstitutional and invalid. Narcoanalysis test, a forensic interrogation technique in which a suspect is administered psychoactive drugs such as sodium pentothal. The drug lowers inhibition, alleging inducing a semi conscious state to extract concealed information, sometimes used by investigative agencies when cooperation is not forthcoming. Key highlights of the ruling: forced narco test unconstitutional. The Supreme Court held that any non consensual or involuntary narcoanalysis test violates fundamental rights and is therefore unconstitutional. Reformation of Selvi judgment. The Supreme Court set aside the Patna High Court judgment in Amlesh Kumar versus State of Bihar 2025 for violating the binding guidelines laid down in Selvi v. State of Karnataka 2010. Limited scope for voluntary test. A narco test may be conducted only with free and informed consent, and that too at a defense stage under Section 253 of BNSS with no absolute right to demand it. Evidentiary bar. Any information obtained through a narco test without consent is inadmissible, and even voluntary test results do not have standalone evidentiary value. Constitutional and procedural safeguards for narco test. Article 20, Clause 3 protects an accused from self incrimination. No person can be forced to testify against themselves. Article 20, Clause 1 prohibits ex post facto punishment. An act cannot be punished if it was not an offense when committed. Article 20, Clause 2 ensures protections against double jeopardy, meaning no person can be tried or punished twice for the same offense. Article 21 guarantees personal liberty and requires that any investigative procedure must follow procedure established by law, ensuring fair and due process before conducting tests like narcoanalysis. Golden Triangle and due process. Any investigative procedure must conform to the Golden Triangle of Article 14, 19, 21 as laid down in Menka Gandhi versus Union of India 1978, making non-consensual narco test constitutionally impermissible. 8. Central Pay Commission Terms of Reference. News: the Union Cabinet has approved the terms of reference for the 8th Central Pay Commission. About 8 Central Pay Commission, 8th CPC. The 8th CPC has been constituted by Union Government to review and recommend revisions in pay, allowances, and pension structure of the central government and employees and pensioners. Composition: Chairperson Justice Ranjana Prakash Desai, former Supreme Court Judge and current Chairperson of the Press Council of India. Part time member Professor Fulak Ghosh, Indian Institute of Management, Bangalore. Member Secretary Pankaj Jain, Secretary, Ministry of Petroleum and Natural Gas. Timeline and implementation: the Commission will submit its report within 18 months, impacting 50 lakh employees and 69 lakh pensioners. The revised pay and pension structure are likely to take effect from January 1st, 2026. Terms of reference TOR. The 8th CPC will make its recommendation after examining the overall economic situation of the country and the need for fiscal discipline, the availability of resources for developing and welfare spending, the unfunded liabilities of non contributory pension schemes, especially pre 2004 obligations under the old pension scheme, the impact on state government finances since most states adopted the center's pay revisions, the comparative pay structure and service conditions of employees in central public sector undertakings and private sector. About pay commission, it is constituted by central government to review salaries, allowances and pensions of government employees. It functions as an advisory body and its recommendations are not binding on the government. It is constituted approximately every 10 years, with the first pay commission established in 1946. It operates under the Department of Expenditure, Ministry of Finance. 7th Pay Commission 2014, chaired by Justice A.K. Mathur, raised the minimum salary to 18,000 and pension to 9,000. Central Information Commission. The Central Information Commission has reached its full sanctioned strength of 11 members for the first time in 7 years after the appointment of Rajkumar Goyal as Chief Information Commissioner. About the Central Information Commission. Nature: it is a statutory, quasi judicial body established under the Right to Information Act 2005. Jurisdiction: CIC covers central government ministries, departments, PSUs, central financial institutions, and union territories. Composition: it consists of one Chief Information Commissioner and up to 10 Information Commissioners. Appointing authority: the President of India appoints the CIC and IC. Selection Committee. Appointments are recommended by a committee comprising the Prime Minister, who is the chairperson, leader of opposition in Lok Sabha, and a Union Cabinet Minister nominated by the PM. Eligibility. Members must be persons of eminence in public life with experience in law, science, and technology, social service, management, journalism, or governance. Disqualification: legislative. A member of parliament or state union territory legislature is not eligible for appointment. Disqualification: others. Members cannot hold an office of profit, be linked to political parties, run businesses, or pursue professions. Tenure: the chief IC or ICs serve for a term prescribed by the central government or until 65 years of age, whichever is earlier. Reappointment: reappointment is not allowed after completion of the term. Removal authority: the President of India can remove CIC on grounds like insolvency, moral turpitude conviction, paid employment, or incapacity. Supreme Court role: removal for misbehavior and incapacity requires an inquiry and recommendation of the Supreme Court. Powers: CIC has civil court like powers, unrestricted access to records, and submits an annual RTI implementation report to Parliament. Bharat NCAP 2.0. The Ministry of Road Transport and Highways has issued a revised draft of Bharat NCAP 2.0, expanding assessment scope and updating safety standards. Proposed changes under the Bharat NCAP: revised star rating system. Under Bharat NCAP 2.0, vehicles will be assessed for crash protection, vulnerable road users, safety, safe driving assistance, accident prevention, and post crash safety. Implementation schedule: the revised framework is proposed to come into effect from October 2027, following the expiry of existing norms on 20 September 2027. About Bharat NCAP: Bharat New Car Assessment Program (Bharat NCAP) is India's indigenous vehicle safety rating mechanism. It evaluates the crashworthiness and safety performance of vehicles sold in Indian market. Star ratings. Vehicles are graded from 0 to 5 stars based on safety standards for adult occupants and child occupants. Objective: to improve vehicle safety, reduce road accident fatalities, strengthen consumer awareness, and encourage manufacturers to adopt higher safety standards. Launch: Bharat NCAP was introduced on 22nd August 2023 by Ministry of Road Transport and Highways. Emphasis is placed on safety techniques such as anti-lock braking system ABS, electronic stability control ESC, seatbelt reminders, ISO fix, child seat anchor, airbags, and overall structural crashworthiness. Vehicle category covered: right hand drive passenger vehicles with a gross vehicle weight up to 3500 kg. 500 years of ICDS program. The Integrated Child Development Service, India's flagship program for early childhood development, marked its 50th anniversary in 2025. About Integrated Child Development Service ICDS program, launched on 2nd of October 1975. Type: centrally sponsored scheme. Nodal Ministry: Ministry of Women and Child Development, MOWCD. Target group: children 0 to 6 years, pregnant women, and lactating mothers. Objective: to improve the nutritional and health status of children, promote early childhood development, reduce malnutrition and child mortality, and support maternal health through integrated community based service. 6 core services: supplementary nutrition, preschool education, health checkups, immunization, referral services, and nutrition health education. Delivery mechanism: services are provided through Anganwadi centers AWC by Anganwadi workers supported by ANM and medical officer. Current status: ICDS has been structured and subsumed under Mission Saksham Anganwadi and Poshan 2.0. Bills and Acts: Viksit Bharat Guarantee for Rojgar and Ajivika Mission Gramin VBG Ramji Bill 2025. News: The Parliament passed the Viksit Bharat Guarantee for Rojgar and Ajivika Mission Gramin Bill 2025, replacing the Mahatma Gandhi National Rural Employment Guarantee Act 2005 (Manrega). Key provisions of the VBG Ramji Bill: higher employment guarantee. The legal entitlement of wage employment for rural households is increased from 100 days to 125 days per year. Revised funding pattern. The scheme shifts to a centrally sponsored scheme with shared cost: 60-40 funding between center and state for most states, 90-10 funding for northeastern states, Himalayan states, and UTs, Uttarakhand, Himachal Pradesh, and Jammu and Kashmir. New allocation mechanism. The earlier demand based labor budget system is replaced by a state wise allocation fixed by central government. Provision for work suspension. States may declare a pause of up to 60 days in financial year during peak farming season, sowing or harvesting, to prevent labor shortages in agriculture. Emphasis on priority rural assets. All works must conform to the Viksit Bharat National Rural Infrastructure Stack, focusing on water security, core rural infrastructure, livelihood supporting infrastructure, climate and extreme weather mitigation. Mandatory digital tools. The bill mandates the use of GIS platform, PM Gati Shakti layer, and AI based audits. Unemployment allowance continued. The provision for unemployment allowance remains payable if employment is not provided within 15 days of application. Sustainable harnessing and management, advancement of nuclear energy for transforming India. Shanti Bill 2025. News: The Parliament passed the Shanti Bill 2025, replacing the Atomic Energy 1962 and Civil Liabilities for Nuclear Damage Act 2010 to reform India's nuclear energy framework and promote expansion of nuclear power. Key provisions of Shanti Bill 2025. Private sector entry opens the nuclear sector to Indian private companies and private government joint ventures. Minority equity cap allows up to 49% private equity in nuclear power projects with majority control retained by the government. Expanded private role. permits private participants in atomic mineral exploration, fuel fabrication, equipment manufacturing, and civil nuclear R&D. Tiered nuclear liability introduces a graded liability cap ranging from 100 rupees crore to 3000 rupees crore linked to reactor capacity. Liability beyond operators cap is borne by central government with a provision for a nuclear liability fund. Operators remain liable for nuclear damage irrespective of negligence and mandatory insurance continues. Removal of right of recourse eliminates the operator's right of recourse against suppliers, contractual clause, and deliberate acts. Statutory regulator grants statutory status to Atomic Energy Regulatory Board AERB to strengthen in nuclear safety oversight. Extended territorial scope compensation extended to nuclear damage occurring outside India if caused by incidents within India, subject to prescribed conditions. Sabka Bima Sabki Raksha Amendment of Insurance Law Bill 2025. News. Recently, the Parliament has passed Sabka Bima Sabki Raksha Amendment of Insurance Laws Bill 2025. It seeks to amend the Insurance Act 1938, the Life Insurance Corporation Act 1956, and the Insurance Regulatory and Development Authority Act 1999. Key features of the bill: higher foreign investment limit. The bill raises the permissible FDI in Indian insurance companies from 76% to 100% of paid up equity capital, allowing complete foreign ownership. Policyholder Education and Protection Fund, a dedicated fund proposed to safeguard policyholders' interest and promote insurance awareness. The fund will be managed by Insurance Regulatory and Development Authority of India, IRDAI. Eased entry for foreign reinsurers. To attract global reinsurers player, the net owned fund requirement is reduced from 5,000 crore rupees to 1,000 crore rupees. Stronger regulatory powers. IRDAI enforcement authority is expanded on the lines of SEBI, enabling it to recover ill-gotten gains and strengthen market discipline. Greater autonomy for LIC. The Life Insurance Corporation of India granted operational flexibility, including the ability to establish new zonal offices without prior government approval. Health Security say National Security Cess Bill 2025. Lok Sabha has recently passed the Health Security say National Security Cess Bill 2025. The bill introduces a dedicated cess on pan masala aimed at strengthening India's public health system and national security funding. It is designed to replace the existing GST compensation cess without disturbing the current GST revenue structure. Key features of the bill: 1. Levy and coverage. The cess is imposed on machinery installed or production processes undertaken for manufacturing pan masala. It follows a capacity based taxation model using parameters such as machine speed, pack weight, or a flat rate for manual processes. Currently limited to pan masala, but the government may extend it to other goods in future. GST framework. Pan masala will continue to be taxed at the maximum GST rate of 40%. The new cess will operate in addition to the GST rate and will not affect GST revenues. 3. Revenue sharing. As public health is a state subject, the proceeds from the cess will be shared with states, strengthening cooperative fiscal support. Enforcement measure. The bill establishes a stringent compliance framework with penalties, prosecution, and confiscation for offences such as undeclared machinery, falsified production data, cess evasion, and obstruction of officials. About cess. A cess is a tax on existing tax collected for a specific purpose, example education, sanitation. It continues only until sufficient funds are raised. Constitutional basis Article 270 Revenue sharing. Cess and surcharges are excluded from the divisible pool. Article 277 recognizes the union powers to levy such special taxes, not share with states unless specified by law, as in this bill. Right to Disconnect Bill 2025. The Right to Disconnect Bill 2025, a private member's bill, was recently introduced in Lok Sabha. About right to disconnect. The right to disconnect allows employees to refrain from engaging in work related calls, emails, or messages outside designated working hours. Its primary goal is to reduce the burden of constant digital connectivity and ensure mental and physical well being. Key provisions of the bill: freedom to ignore work communications after office hours without facing disciplinary action, Employees Welfare Authority to implement and monitor compliance. National baseline study to assess the impact of digital communication on employees outside work. Mandatory negotiation for companies with over 10 employees to frame rules for work beyond office hours with overtime paid at normal rates. Counseling services and digital detox centers coordinated with government. Penalties for non-compliance up to 1% of the total employee remuneration. Private Members Bill introduced by MPs who are not a minister, discussed in Parliament only on Fridays, rarely becomes a law. Since independence, only 14 private member bills have been enacted, the latest in 1970. Global examples: Australia 2004 enacted statutory right to disconnect, joining nearly 2 dozen countries. France 2017, one of the first countries to introduce formal legislation. Argentina provides a legal right to disconnect for teleworkers outside the agreed working hours and during leave. Status in India: India currently lacks specific legislation for the right to disconnect. However, constitutional provisions support worker welfare. Article 38: The states shall strive to promote the welfare of the people. Article 39E: The state shall direct its policy to secure the health and strength of workers. Tribunal Reforms 2021. News: The Supreme Court struck down parts of the Tribunal Reforms Act 2021, holding them unconstitutional, and directed the centre to set up a National Tribunals Commission within 4 months. About tribunals: Tribunals are specialized adjudicatory bodies with quasi judicial powers established to ensure speedy and expert resolution of disputes in specific sectors such as taxation, intellectual property, environmental regulation, and administrative matters. Constitutional basis: Tribunal derives their authority from the Constitution, primarily under Article 323A, which provides for administrative tribunals. Article 323B, which allows for the creation of tribunals for matters like taxation, land reforms, labor disputes, and industrial adjudication. In Supreme Court 2010, it was clarified that the subject listed under Article 233B are not exhaustive, and the Parliament or state legislature may establish tribunals in other fields using their legislative competence under 7th Schedule. Jurisdiction and appellate structure. Each tribunal operates within a clearly defined and limited jurisdiction confined to its specialized subject area. As a general rule, appeals from tribunal lies before the respective high courts unless a statute explicitly provides for a direct appeal in Supreme Court. Tribunal Reforms Act 2021 provisions struck down by Supreme Court. Minimum age of 50 years. The act barred appointment of person below 50 years as tribunal chairperson or members. Held arbitrary and violative of Article 14 as it excludes eligible advocates with 10 years of practice. 4 years fixed tenure provided a 4-year term with age limit of 70 years chairperson and 67 years member. Court reiterated that a minimum 5-year tenure is necessary to ensure security of tenure and prevent executive influence. Panel of 2 names for appointment. Search cum selection committee was required to recommend 2 names per vacancy. Court held this diluted judicial primacy, reiterated that only 1 name per post should be recommended. Service condition linked to civil servants, equating tribunal members' allowance and benefits with civil service was invalidated. Court held that tribunal members, being quasi judicial officers, must enjoy service conditions comparable to High Court judges. Panchayat Extension to Schedule Area Act 1996, PISA. News: The Ministry of Panchayati Raj recently organized PISA Mahotsav 2025 at Vishakhapatnam, Andhra Pradesh to commemorate the enactment of Panchayat Extension to Schedule Area Act 1996. About PISA 1996, enacted to extend Part 9 of the Constitution, Panchayati Raj institutions, to Schedule Area notified under the 5th Schedule. Constitutional basis: Article 243M 4B. Objective: to adopt democratic decentralization to the distinct social, cultural, and customary practices of tribal communities. PISA Mahotsav 2025 Key highlights: Official mascot Krishna Jinka, black buck, symbolizing agility, resilience, and tribal harmony with nature. Central theme: Utsav Lok Sanskriti Ka emphasizes culture as foundation of governance, rooting authority in indigenous knowledge and tradition. Cultural assertion, indigenous games such as Chakki Khel, Pulli Meka, Malakhamba, Gedi Dod, etc. were showcased, underlining culture as an integral component of self-rule. Capacity building, training materials released in Santali, Gondi, Bhil, and Madurai, addressing linguistic barriers to participation. Policy update, with Jharkhand notifying PESA rules 9 out of 10 fifth scheduled states have framed rules. Odisha remains the only exception. To the point, terms, initiatives, and news. Doctrine of clean state. Context: the Delhi High Court upheld the clean slate doctrine under the Insolvency and Bankruptcy Code, freezing new owners from past liabilities of corporate debtors. About doctrine of clean state. Under the Solvency and Bankruptcy Code (IBC 2016), clean slate doctrine allows a resolved company to begin afresh, free from past debts, penalties, and liabilities. Legal basis: Section 31 of IBC makes the approved resolution plan binding on all stakeholders, including government bodies. Objective: to attract investors, provide certainty, and ensure smooth revival of insolvent firms. Note: it protects the corporate debtors, not its former directors or management, who may still face personal or criminal liability. Article 240. Context: the Centre is weighing a proposal under the Constitution 331st Amendment Bill 2025 to bring Chandigarh under Article 240. At present, Chandigarh is a union territory without a legislature and is administered by Punjab Governor with additional charge. About Article 240. Article 240 gives the President of India the power to make regulations for the peace, progress, and good governance of certain union territories, such as Andaman and Nicobar Island, Lakshadweep, Dadar and Nagar Haveli, Daman and Diu. These regulations can amend or repeal any existing law, including laws made by Parliament, applicable to those union territories. Implications of bringing Chandigarh under Article 240. If Chandigarh is brought under Article 240, the centre, through the President, would be able to make laws for Chandigarh directly, instead of depending on Parliament for every legal change. Electoral Trust. Context: after the Supreme Court scrapped electoral bond in February 2024, electoral trust became the main transparent route for political funding. About electoral trust. Electoral trusts are non-profit entities created in 2013 to receive voluntary political donations and distribute them to the registered political parties in a transparent manner. Legal status: they must be set up as Section 8 companies under the Companies Act 2013. Objective: to ensure regulated, transparent, and accountable political funding, especially for large donations. Eligible donors: as per Section 17CA of the Income Tax Act 1961, donations can be made by Indian citizens, Indian companies, firms, HUF, and associations of persons based in India. Mode of donation: contributions must be made only through banking channels, check, demand draft, or electronic transfer. Cash donations are prohibited. Donor identification: donors are required to furnish PAN for residents or passport number for NRIs, ensuring traceability. Global Indices for Reform and Growth (GIRG) framework. Context: the Government of India is strengthening efforts under GIRG initiative to improve its ranking in 26 global indices. About GIRG framework. GIRG is a coordinated government initiative to enhance India's global ranking by systematically improving performance on major international indices. Objective: it aims to identify gap, align national data with global methodologies, and drive targeted reforms to support growth. Scope: the initiative tracks 26 global indices published by 16 international agencies. Thematic coverage: these indices are grouped under four themes: economy, development, governance, and industry. Institutional coordination: the Development Monitoring and Evaluation Office (DEMO) Niti Aayog acts as knowledge partner and central coordinator. Ministerial accountability: 17 nodal ministries are assigned specific indices and are responsible for data validation, engagement with global agencies, and implementing reforms to improve ranking.